Hi everyone, happy Wednesday and thanks for joining us for this webinar. I'm Gwendolyn, the Community Engagement and Event Leads here at SFA. So today's session is the first session of a three-part series on PDPA organized by SFA and Personal Data Protection Commission. But for today's session, we have Justin Lee from Raja & Tan, Singapore to share more about responsible data practice and the free tools and resources available to help you comply with PDPA. So if you have any questions along the way, please feel free to drop them in the Q&A function in the Zoom below, and we'll try our best to address them at the end of the session. So without delaying any further, I'll hand over to Justin. Justin, please.
Right, thanks a lot, Gwen. Again, thanks everyone for taking the time to, out of your busy schedules to attend this webinar. I'm a partner at Raja & Tan's technology team, and I'm here on behalf of the PDPC to speak to you a little bit more about today's topic, which is a trusted imperative compliance with the Personal Data Protection Act, or PDPA. As Gwendolyn mentioned, this is a first of a three-part series. One second, my slides are not moving. Yes, the first of a three-part series about PDPA and data protection compliance. And you will be, for those of you who have signed up for all three sessions, you're going to be seeing me again in the next two sessions in May and June. So this kind of overview of what this whole series is meant to achieve. For today's session, I think the main thing that we kind of want to set out is pretty much just an overview of the Personal Data Protection Act in Singapore, and also what kind of risks and opportunities exist and arise in relation to the use of data, and how by achieving accountability in compliance with the Personal Data Protection Act, or the PDPA, it really can represent an opportunity for your organization to get ahead of the competition, to strengthen your consumer relationships and things like that. Right, so it really goes without saying in today's economy, and I'm sure that is something that all of you are very well aware of, is that data today is a fundamental resource for any kind of business. Whether it's whatever industry you're in, but especially for fintech organizations like yourselves, the ability to use data effectively and in an accountable manner really represents a significant competitive advantage if you're able to do so. That's because data can be used in so many different ways across your business, such as to improve your work efficiency, improve customer experience, deliver a more tailored customer experience to your consumers based on what you know about them, to make informed business decisions based on data, deploying your analytics tools and increasingly AI nowadays, and also to innovate your products and services. All of these represent the huge upside that exists when it comes to being able to take up data and manage it effectively. But on the other hand, that what I just mentioned is the upside. But when it comes to data, the more data that you have, while there is a huge upside, there is a huge necessity for that in your business. It does come along with it a significant amount of risk, right? The more data you have, the greater amount of risk that will exist. And one common or key facet of this is the idea of data breaches and cyber attacks. It's a common adage in the industry that when it comes to data breaches, it's really not a question of if, but when you're going to suffer a data breach. The statistics here kind of bear them out. If you look at the statistics that we put together, 1 in 3 Singapore organizations have lost up to $1.3 million from data breaches, and nearly half of the attacks involve credential hijackings. Similarly, for small companies, this is particularly fatal because for 60% of them, if they suffer a data breach or they suffer a hack, they close within 6 months of suffering that. Sorry, give me a sec. I think to just plug in my computer. It seems like my video is freezing a little bit. Sorry about that. Just 1 second. Yeah, sorry for that minor delay. As I was saying, these kind of data breaches can be particularly fatal for small companies who may not have the resources to address these breaches effectively. And 60% of them close within 6 months of being hacked, and 3 in 5 SMEs suffer cybersecurity breaches over the last 12 months. So what this really bears out is that this is definitely a very real risk that exists when it comes to data, and the impact can be severe if the organization is not prepared for it, is not sufficiently resilient enough to bear the impact of the breach. Right, so having set the scene and the overall context of the use of data, what I will now turn to is to provide an overview of the PDPA and to sort of demonstrate how the various obligations of the PDPA within that framing, while it does represent legal obligations and statutory obligations that our companies do need to comply with, at the same time, it does represent the ability to effectively and accountably comply with these obligations does represent a huge opportunity for businesses as well. Right. So the PDPA, it came into effect in 2014 after being passed in 2012. Essentially, it governs the collection, use, and disclosure of personal data by organizations in a manner that balances two key considerations. First, the right of individuals to protect their personal data. It recognizes that personal data belongs to certain individuals, and those individuals do have a right to protect their personal data and to exercise certain rights over that personal data. And on the other hand, the key competing impetus of organizations and their need to collect, use, and disclose the data for their reasonable business purposes. The PDPA was further strengthened following a major set of amendments in 2020, which were aimed by the PDPC to further strengthen both sides of this equation, both the consumer autonomy as well as the business needs on both sides. So to really flesh out further and draw a greater balance between those two. The PDPA comprises of the data protection provisions, which are the main ones we're going to talk about later. But there's also an important component called the do not call provisions, and those primarily deal with the use of personal data to send marketing communications. So whether it's via marketing calls or marketing emails or marketing messages, that kind of thing. I'm not going to touch too much on the DNC for this session, but just to sort of set the structure of the PDPA that's divided into these two broad areas. When it comes to personal data, that's defined in a very common sense manner. Essentially, it means data about an individual who can be identified from that data, or when you take that data and you combine it with other data that the organization has or is likely to have access to. So personal data is either data that can identify an individual on its own, or when you combine the data with other data, that combination of data enables you to identify an individual. The flow chart at the bottom gives a very sort of typical or common flow of data. And from the diagram you can see, collection of data at the start of the data lifecycle can come in various forms, like when you collect customer information when they sign up for your services, when they're onboarded to your platform, enrollment forms. If there's an event and someone signs up to an event that you've organized, they give you their data when signing up for that. Employee records and membership forms. So those are various data sources that exist. Next, once you collected the data, how are you going to use it? Right, again, that can take so many different forms. Depending on what kind of data you've collected, you can use it for all sorts of things within your business. And yeah, I mean, I don't think there's really a need for me to go into it, but essentially you're going to use that data for various business purposes. And part of that will include the disclosure of that data. So not just use within your organization, but to pass it on to other organizations who need the data for that purpose, part of your business purposes. So such as your affiliates, your headquarters for some centralized functions, your business partners, your vendors. You may pass that collected personal data onto them for various reasons. Right, so this slide here, this is an overview of the data protection provisions or obligations under the PDPA. And you will find that they are characterized or grouped in a way that aligns with that data lifecycle that I mentioned just now. If we start from the blue box on the right side, those are the obligations that deal with the collection of personal data. So essentially under the PDPA, when you collect that personal data, the key requirement is to obtain consent. The PDPA is a consent-based regime, which means that in terms of the legal ability to use certain personal data or to collect certain personal data, it's primarily based on getting the individual's consent for such collection and use. There are certain statutory exceptions to that, but primarily in the absence of those exceptions, the key requirement is to obtain consent. Alongside that consent, there is the accompanying obligations of notification and purpose limitation. Notification works hand in hand with consent because when you are obtaining consent, you need to notify the individuals of the purposes for which you are collecting and using that data. And those notified purposes create or form the boundaries of the consent that's being provided. Because when it comes to using the data subsequently, you are only able to use the data for the purposes which have been notified and consented to by the individual at the point of collection. For any new purposes that were not part of those that were notified, there's a need to obtain fresh consent before you can use that data for the new purposes. Obligation number 4, purpose limitation, that works together with that as well, because when it comes to the purposes that you can use the data for, even if you obtain consent for it, there is still a underpinning obligation for the purpose to be one that is reasonable in the context or circumstances of your business and what is being collected. So ultimately, these three work hand in hand to sort of set the framework in which you are able to collect and how you're able to collect personal data in compliance with the PDPA. Moving on to the green box at the bottom, that is the second part of the data lifecycle. So after you collected that data, now it's in your organization's care and control. What do you need to do in respect of data? And the key sort of area here is that the organization need to take care of it, essentially. The most important one will be obligation number 6, which is the protection obligation. And this is really the obligation that most organizations fail to comply with and lead to penalties being imposed under the PDPA for breach of the PDPA. This is the obligation that's breached the most often. And very simply speaking, the protection obligation means that you are supposed to put in place appropriate technical and organizational measures to make sure that whatever data is in your care and control is kept safe from any kind of unauthorized disclosure, unauthorized use, unauthorized access. Basically, you're supposed to keep the data safe and secure, right? To put it very simply. Of course, what this ultimately entails is a lot easier said than done, because it can involve a whole slew of different specific measures that you're going to put in place, whether it's IT measures, policies, organizational measures. These all work hand in hand to make to form the framework of keeping the data safe and protected from any kind of unauthorized harms. I will touch a bit more later in the presentation about what this could mean in a practical basis. But suffice to say, this is the sort of most commonly breached obligation under the PDPA. The rest of the obligations under the green box, number 5, accuracy. Simply that just means that you have a general obligation to make sure that whatever data you have in your care and control is accurate. It doesn't mean that you need to be 100% sure that it's accurate all the time, because the data comes from the individual, right? Sometimes you won't know, right? But what is required is to have in place reasonable measures to check and make sure that whatever you have is accurate and continues to be accurate if you're continuing to use it for a long period of time. Number 7, retention limitation. This obligation deals with how long you can keep the data for, how long an organization can keep the data. Very simply, organizations generally can keep data for as long as 2 things are true. First, as long as the purposes for which you have collected the data and notified them to the individual continue to be valid, continue to exist. And second, if you need the data for any other business or legal purpose, legitimate ones, of course. There is no right to right of deletion under the Singapore PDPA, unlike other jurisdictions such as the GDPR in Europe, for example. So there is no ability or right of individuals to request for data to be deleted. So whether you can retain data or not, irrespective of the desire of the individual, rests on the existence of the two sort of purposes that I mentioned earlier, whether those continue to exist in terms of the retention of data. Number 8, transfer limitation deals with the transfer of data from Singapore out of Singapore to other countries. Very simply, the obligation is to make sure that there's different ways to comply with it, but in a very broad sense, what is required is to make sure that when you transfer data out of Singapore, the recipient of that personal data in the other country overseas is subject to legally enforceable obligations to protect the personal data to the same standard that is provided for under the PDPA. Essentially, the thinking here is that the personal data should not lose the protections or standards of protection of the PDPA just because it is transferred to a country overseas. So the obligation is on the transferring organization in Singapore to make sure that whoever is receiving it overseas is bound by that level of protective obligations before the data can be transferred. The next box in the data lifecycle refers to the individual's autonomy over personal data. So this is the orange box. So when I mentioned earlier that there was no right of deletion under the PDPA, these are what rights that individuals have. So there is primarily the access and correction right, which is obligation number 9. Very simply, it's the right to know and be informed by the organization what personal data of an individual is in the possession of the organization. So the individual can come and ask you that, right? What personal data do you have about me and how have you used it in the past 1 year? And the organization is required to give that information to the individual. In terms of correction, similarly, the individual can submit a request to the organization to say, okay, there's some part of my data that is not correct, is outdated, I've moved house or whatever, here's my new address. That is sort of the right to correct the personal data and to update it to whatever is currently accurate. Just moving quickly to obligation 11, that obligation is another right that individuals can exercise. It's the right or the ability to request for the data to be ported from your organization to another organization in a specified manner or to a specified category of organizations. This obligation is in a dotted line box because it's not in effect yet. And it's pending the issuance of further regulations by the PDPC, which will specify and delineate when exactly and how exactly this obligation is meant to be complied with. But we're just putting it here just to provide a heads up as to that this obligation exists and is coming soon once the regulations are issued. Right. So moving back to number 10, this is another very key and important obligation. It's the data breach notification obligation. As I mentioned earlier, it is really a matter of time that a data breach is going to happen to your organization. And it doesn't have to be like a major hack or a major cyber attack even very small things like, I send an email containing a customer's personal data to the wrong recipient. I meant to send it, instead of sending it to Benjamin Tan in my office, I send it to a Benjamin Tan in another company. So that also could potentially be a data breach, which is why it's important to be aware of this obligation. The data breach notification obligation essentially requires organizations to notify the PDPC or the affected individuals if the data breach that has occurred. Firstly, if a data breach has occurred within the definition of the PDPA, and secondly, if the data breach that has occurred is one that meets the notification thresholds. There are 2 notification thresholds. The first is in terms of the severity of the breach, in terms of what kind of data was affected, whether it's some kind of sensitive data, and secondly, in terms of the scale of the breach, when it comes to how many individuals' data was involved. If it crosses the threshold of 500, then it needs to be notified. There's going to be another slide later that kind of illustrates this more clearly. So let's just park that aside for now. And finally, the overarching obligation at the top, obligation number 1, which is accountability. This is the sort of principle that underpins everything under the PDPA. And as I mentioned at the start, the desire of the PDPC and the regulatory impetus of the PDPC is to make sure that organizations don't approach the PDPA as a kind of box checking exercise whereby, oh, okay, there's this like obligation 2 to 11. I gotta do ABC and I just do ABC. I just fully comply with the letter of the law and nothing further. I think the idea of this accountability obligation is to create that principle, that spirit of accountability that organizations can use and apply to their businesses and their data protection policies and processes, such that when it comes to assessing whether any of the other obligations have been complied with, the PDPC will look at the extent to which the so-called spirit of accountability or principle of accountability has been put into effect in respect of those compliance measures lah. So in other words, I think what I'm trying to say is that even if you do something that is the bare minimum technically based on the reading of the wording of the requirements, it may not be sufficient because of the fact that as has been clarified, the PDPC in its various enforcement decisions and its guidelines, what is needed is really something that demonstrates a spirit and principle of accountability in doing so, like in complying with those obligations. Right, so now next I'm going to briefly touch on some of the changes that were introduced in the recent amendments to the PDPA. I mean, I guess not so recent anymore, but which took place in 2020. And to sort of further demonstrate how the PDPC is further strengthening and deepening that balance between the need for businesses to use the data and the need for businesses to protect the rights of individuals in respect of their data. So first, there is an enhanced framework to support data use. So this is on the business side of things. The various exceptions to the PDPA's consent requirement that I mentioned earlier, these were all enhanced in various ways during the 2020 amendments to create and give more ways and tools for businesses to process and collect personal data, even particularly in situations where it may not be commercially practical or feasible to obtain the consent of the individuals involved. So this will include things like the business improvement exception, whereby if you're going to use data for specific business improvement purposes, it is possible to do it without obtaining consent of the individuals involved. The broad legitimate interest exception, whereby instead of obtaining consent, what you can do is to conduct a data protection impact assessment, whereby you assess that this particular purpose that you want to use, the legitimate interest of your business outweighs whatever specific downsides or detriment to the individual that may arise from not getting their consent. So having conducted that formal assessment, if you can demonstrate that your legitimate interests do outweigh that downside risk, and you have put in place measures to mitigate the downside risk to the individuals, you can, on that basis, go ahead and collect and use the data without obtaining the individual's consent. Similarly, the business asset transaction and research and development exceptions were expanded to be a bit more comprehensive, a bit more business friendly in terms of how it actually operates in practice. And at the bottom, the concept of deemed consent, which is not quite an exception to consent, but rather an alternative form of consent, whereby the individual is taken to have consented based on certain conduct rather than the express indication of consent. Those will also strengthen and broaden to give the businesses more tools to obtain consent in a way when in situations where obtaining express consent may not be practical. So that will include deemed consent by contractual performance. So if you and the individual have entered into a contract for certain to do something, and the processing and collecting of personal data is necessarily required for that something that you've contractually agreed to with that individual, then the individual can be taken to have deemed consented to it by virtue of the fact that they had entered into a contract with you. Otherwise, that contract can't be fulfilled, right? So that's why there's deemed consent is taken to have arisen from that situation. Similarly, deemed consent by notification, that is another mode of obtaining deemed consent whereby you've conducted a DPIA, a data protection impact assessment that I mentioned earlier, and following that, you send out a notification to a number of individuals and say that, if you don't opt out or don't respond no by a certain date, you'll be deemed to have consented by virtue of this notification lah. I just want to caution here that this doesn't mean this is not to say that opt-out consent is fine in all circumstances. But just to highlight that there is a specific option to obtain deemed consent by notification, and there are specific steps that need to be done and complied with before you can go ahead and obtain deemed consent by notification lah. Right. Sorry, this is kind of whatever I just mentioned. So, yeah. Right. So, coming back to the mandatory data breach notification obligation, as I mentioned, this is a very, very important obligation because it's the one it's going to come up quite frequently, and your organization is going to be no exception to this rule lah. So as I mentioned, there is an obligation under the PDPA in the event of a data breach to either notify the PDPC and or the affected individuals. The PDPC must be notified if both the significant harm threshold as well as the significant scale threshold have been fulfilled. In either of those cases, you need to notify the PDPC. But the individuals only need to be notified if there's going to be significant harm to them lah. So no matter how many individuals are involved, that's not relevant when assessing the notification to the affected individuals. There's some exceptions to this requirement as highlighted in that dotted box with the green text in it. But I guess I'm not going to go into it at this point because it's a bit technical. But suffice to say, there are certain that in certain circumstances where you've mitigated the risk of harm to the individuals, then you don't need to notify the affected individuals, but you still need to notify the PDPC. So to expand a bit further on the significant harm threshold, as I mentioned, it's really that is an assessment of the severity of the incident and particularly the types of personal data involved that would result in significant harm to the affected individuals. There is a set of regulations under which it is statutorily defined or deemed based on certain combinations or categories of data that as long as this kind of data is affected, the significant harm threshold is going to be triggered. And I think a notable example would be example 1 here, where if there is a combination of the individual's name or IC plus any kind of financial information about the individual, and I think that's relevant given that you guys are in the fintech industry. It is quite easy to trigger the significant harm threshold, given the nature of the information involved. So it's not all financial information, but financial information of a certain nature that is going to trigger the significant harm threshold. Similarly, if you look at example 2, for those of you guys who operate online fintech platforms, for example, if there's a combination of the individual's account information like username together with the password of the individual, that combination will already be sufficient to trigger the significant harm threshold. So in both of these cases, it is deemed by statute, by law, that significant harm is likely to result, and therefore the PDPC needs to be notified of the incident. In terms of timelines, when it comes to the data breach notification obligation, this is also another critical point because data breaches are all time sensitive. Not just from a regulatory perspective, because when it comes to data breach, time is of the essence. You're being able to quickly mitigate and resolve and minimize the impact of the data breach is critical. But similarly, from a regulatory perspective, time is also of the essence here lah. If you look at the timeline at the bottom, there is a 30 calendar day timeline after you are aware of a data breach that has happened, within which you must take expeditious steps to investigate the incident and to determine whether under the thresholds that I mentioned above, whether the data breach needs to be notified to the PDPC and or the affected individuals. Typically, this 30-day calendar window is where you start to engage your forensic experts, your lawyers to do the formal legal assessment as to whether it needs to be notified lah. Once that determination has been made, following the date of that determination, you have to submit your notification to the PDPC within 3 calendar days of the assessment. So 3 calendar days includes weekends, public holidays. It needs to be submitted to the notification needs to be submitted to the PDPC, and this is typically done via the online web form on the PDPC's website. Concurrently, on or after notifying the PDPC, if there is a significant harm threshold that's being triggered, the affected individuals also need to be notified in accordance with the form and requirements set out under the PDPA. So the 2 slides that came before this kind of demonstrated the strengthened balance between the business needs of the organization as well as the need to protect the individuals from harm. And both of these are sort of strengthened further by the enhanced powers of the PDPC to impose financial penalties for breaches of the PDPA. As of the amendments, organizations can be fined by the PDPC for breaches of the PDPA up to 1 million Sing dollars or up to 10% of the annual turnover in Singapore, whichever is higher. Previously, it was just a 1 million hard cap. So bigger organizations were kind of getting a proportionally smaller penalty, right? So now for larger organizations where your annual turnover is 10 million or more, you could be fined more than $1 million for very serious breaches of the PDPA. There's also individual offences when it comes to egregious mishandling of the PDPC in a knowing or reckless way, where you know or are reckless to the fact that whatever you're doing is unauthorized by your organization, by your company, by your employer. There can be individual criminal penalties imposed of a fine of up to $5,000 or imprisonment or up to 2 years or both. Right. So continuing on the thread of data breaches, given that I mentioned that is a very critical and important area that everyone's going to have to confront eventually. What I'm going to quickly touch on is how to guard against common types of data breaches. And the top 5 common gaps that result in data breaches within your IT systems and processes have been identified by the PDPC as the following. The most common is coding issues, and other categories would include configuration issues, malware and phishing, security and responsibility issues, and issues with compromised accounts and passwords. I'm going to go into some examples that illustrate each of these. So first, for coding issues, which is the most common identified by the PDPC, very simply, this is an error within the code of some software or platform that your organization is using to process or store personal data that results in the personal data being leaked out, being exposed, being subject to unauthorized access or disclosure. This, for those of you all who are in the software development field or the software engineering field, I think you're probably aware that even the smallest mistakes, like you have one typo, you change a plus to a minus, sign that can be enough to lead to a huge issue when it comes to data leakage. The 2 case examples here are in point. First example, where the organization needed new codes to interact with an existing API, but because they didn't document the API correctly, the developer made some incorrect coding assumptions, and that caused the API to display customer information wrongly. So either displaying the wrong customer's information to the wrong customer, or displaying too much information that more than what was intended. Similarly, in case example 2, the coding error led to the wrong data field being used when creating a lookup query. So when the search lookup was prompted, the incorrect records of many persons were pulled out instead of just the one person's data lah. So in other words, a customer was able to access the data of 10 other customers instead of just his own personal data. So to address this, what is critical is really to test. I think that is the most obvious and direct way of addressing this lah. When it comes to the coding, when it comes to the documentation, those are important as well. You gotta make sure that throughout the development phase, it's very clear what is intended to do what is the intended function of this software or this platform, and the coding is done in accordance with that. But ultimately, you will really probably not ever know whether you've coded something correctly or not unless you've tested it thoroughly. So the most important thing here is to really test your systems religiously in a very thorough way before you put it live on your live production environments. And also the testing, right? Unit testing, regression testing, security testing, user acceptance testing. Only by testing it very, very thoroughly that you can demonstrate that, okay, there is no flaw in the system, it is functioning as intended. Alongside the testing, there's also code reviews that you can conduct to make sure that someone else is checking the coder's work to make sure there's no errors in there lah. Okay, next, configuration issues. This is similar but not exactly the same as a coding issue. So instead of the software code that has an error, it's really a configuration setting that was not done properly that led to the data being leaked out lah. So this will range from, for example, a WordPress plugin that was not configured properly that led to the public being able to access the private database of the company. Again, the recommendation here is to harden your configurations by making sure that you set all your configurations correctly and don't just rely on the default settings. Second example, it's about the failure to store or document the code in a correct way that led to an outdated copy of the code that was being retrieved and put on live. Because the code was outdated, it led to disclosure of personal data. Next, wrong URL for the antivirus software updates to be downloaded from, which resulted in antivirus being updated for an extended period of time. And because of that outdated antivirus software, the malware was able to infect the systems. So again, very simple error that led to major consequences lah. Okay, next. So speaking of malware, this is another big one. And malware and phishing really exploits the human element of organizational IT security, which can often be and is often viewed as the weakest link of any kind of IT security, the human element. So this is a very common problem nowadays, and it's important to make sure that everybody is alert and well-trained within your organization to spot and not fall victim to malware and phishing attacks, no matter how convincing they are. So this would typically take the form of malicious links in phishing emails, and some of these can be very convincing, right? I think anecdotally, these are gonna get scarier, I would say, with the increasing adoption of AI and deepfakes. I'm not sure if some of you are aware, but there have been reports of going around in other countries where they were able to create a very convincing deepfake of the company's CEO, and they used that deepfake to call the financial officer to request the financial officer to release or transfer a certain amount of money to a particular bank account. And because the deepfake was so convincing, and because that particular company it was from a society where we have a very strong culture of compliance with authorities' instructions. The financial officer just complied, right? Like it clearly looked and sounded like his boss. So he went ahead and transferred the money to the scammers, and that was it, right? So what needs to be done here is really to be have in place education and training to make sure that everybody is prepared to identify and respond appropriately to this kind of malware and phishing attacks, no matter, and to continue keep up to date with the different attack patterns and attack forms of attack, so that your organization, your employees, your staff, they are able to respond accordingly, right, and not fall victim to these attacks. For case example 2, it's a bit different. I guess it's not quite phishing, but it's more like because the IT staff left, the system was not patched, there was no security reviews or checks conducted. The guy left, then nobody took over his job. So because of that caused the systems to be affected by malware and ransomware. So this is more of IT security rather than malware and phishing. And what it speaks to is really the need to have strong IT security, endpoint security solutions, have proper data backups and all that, all appropriate responses for ransomware attacks. So it kind of ties a little bit more into this category of security and responsibility issues. And when it comes to IT security, it will be it must be clear who is responsible within your organization. I think typically it will be your CISO, it might be your CTO, depending on how those roles are allocated within your organization. But essentially there needs to be that level of responsibility and in-depth responsibility for the IT security of the organization. So for example, the case examples here, number one, there was a text file that contained personal data in a test environment that was placed there for testing purposes, but it wasn't removed after testing. The issue was that this test server was publicly accessible and indexed by search engines. So people searching for this on the internet could have found it based on a very simple, search engine search. So this was clearly a mistake. It should not have been done. Not just the fact that it was publicly accessible, but even using actual personal data for testing rather than synthetic data. Those were the issues that led to the breach in that instance. Case example 2 is another important one. And it's about the allocation of responsibility between an organization and its IT vendors. And ultimately what this speaks to is it must be clear between you and the vendor, and it must be clear in a documented and written way who is responsible for protecting their personal data. And this will be an issue that will be touched on in the second and third sessions of this webinar. So just at this point, it's just important to highlight that it is a key issue to take in mind when it comes to IT security. And finally, very simply, accounts and passwords. Those are the locks and keys towards your system. Once they're compromised, if someone gains the key, then they can access your system. I think that just goes without saying, right? So what can be done to protect and make your system more resilient against those attacks, or the breaching of those locks and keys, those accounts and passwords? That would be in the form of a number of very nowadays very common protections. So such as minimizing brute force attacks, whereby if your system detects a number of logins that beyond a certain amount within a certain amount of time, it should trigger a certain challenge, such as a capture challenge to make sure that whoever is doing this is in fact a human person and not a bot that is conducting a brute force attack. There should be strong passwords that is backed up together with 2FA, particularly for administrative accounts or accounts which have a high level of data access. And again, along those lines, if you look at case example 2, the database login credentials should not be exposed or found in code or configuration files. I think we found that this was a fairly common and unwelcome practice for coding a couple of years back for older systems, whereby the code itself, the account passwords themselves were stored within the code because of the way it was coded, right? Because it's coded in a kind of outdated and incremental way. It was not the organization. They just had the code they just had the password stored within the code, whereby anybody who has access to the code can find the password. So that was clearly an issue, because then your password is just out there on your GitHub or whatever, and available for access. Right. So the final topic or area that I'm going to touch on today is, okay, having sort of set the scene of what is the PDPA, what is expected. When we talk about data breaches, we talk about how you can avoid data breaches, and if they do occur, how you can notify, what do you need to do in response to that. What we're going to move on now to talk about is having set that sort of scene as to okay, what needs to be done. We like to talk about what are the help and resources that are available from the PDPC for organizations who are seeking to implement data protection policies and processes, and achieve accountability under the PDPA. There are, to put it simply, many resources that the PDPC has made available, and I think you can find almost all of these on the website of the PDPC. I'm going to touch on a few of these in particular, but very broadly, it comes with training, industry briefings like this one that I'm conducting today. It comes with organizations who are starting out. There's a PDPA assessment tool that they can use to assess what are the gaps in their organization's PDPA compliance. In terms of the implementation of PDPA compliance, there's templates that the PDPC has put in place, has made available on its website. There's certain generators they can use to create a template, data protection notice. And to take it a further step beyond that, there's capability building offerings that the PDPC has for both DPOs as well as other people who are involved in data handling or data protection within the company, to increase their skills and proficiency and knowledge in the realm of data protection, so as to help the organization to strengthen its data protection posture overall. Right. So first thing, every organization has to have a DPO. Okay, that's a requirement under the PDPA. And the requirement under the PDPA is also to have the DPO's business contact information made available to the public. The PDPC does encourage, over and above these statutory requirements, that organizations register their DPO with ACRA as well as the PDPC, to meet the accountability obligations, so that the PDPC has the DPO's contact information on file and is available on ACRA as well. But this is not a strict legal requirement. Right, and in terms of the resources that are available for businesses throughout their life cycle, for new SMEs, for example, there is a Go Digital SME Start Digital Pack, or SMEs Go Digital Start Digital Pack. Essentially, these are like the basic building blocks that are put together in a simple pack that new SMEs can access to have foundational security solutions to safeguard their personal data and data loss from cyber incidents. And moving on to SMEs that are, still SMEs but not so new, the resources would include data protection essentials, which is sort of a package vendor, PDPC vendor solution that they can use to achieve PDPA compliance in a cost-effective way. The next slide will touch a bit more on that. There's also better data-driven business. I believe there's also another slide on that, but essentially that one is that this particular initiative is the PDPC's business intelligence tool that they made available to enable organizations to kickstart their data analytics processes, and also training in terms of the use of this BI tool. And finally, for all organizations, for those who are more advanced, for those who have sort of achieved that gold standard of compliance with the PDPA, there are certifications that can be achieved, such as the Data Protection Trust Mark and the APEC cross-border privacy rules and privacy recognition processes. These are certifications that your organization can apply for, to symbolize and to demonstrate to the public that your organization has achieved that gold standard of compliance that the PDPC is looking for. All right, so to touch a bit further on whatever I just mentioned, in particular the DPA first. As I mentioned, the DPA is a package framework that is designed for SMEs to provide a baseline standard of data protection. There's this 7-step package that exists, and what what this can be done either by self-implementation, using the resources and templates that are available online by the PDPC and CSA. Either that, or if you feel that organization needs help from some professionals, there are a set of IMD appointed service providers that are listed at the bottom of the slide, who are offering this data protection essentials package, that would be a more cost-effective way, there's sort of a cost-effective package that SMEs can tap on to achieve data protection compliance with the assistance of a vendor. So sorry, just before I move on to the next slide, I think it's important to note that when it comes to a data breach, the PDPC may consider an SME's implementation of the DPA favorably when they study an enforcement outcome lah. I think that's because I think the PDPC will recognize that the organization has taken steps to ensure that it is compliant with the PDPA, that it is protecting the data to the standard that's expected under the PDPA, and that is demonstrated by the engagement of the DP framework. So if there is proof of that, the PDPC would look on that as a positive factor that may have a mitigating impact on any kind of finding of breach or financial penalty that's imposed by the PDPA. Right. And next, there is the IMDA Data Protection Trust Mark. So as I mentioned, these are for organizations that have sort of achieved the gold standard of compliance to the PDPA. And ultimately, it's if you're able to pass this, it's a sort of badge or certification of that gold standard that demonstrates compliance and accountability, and it lasts for 3 years, and it's ultimately a validation of the organization's data protection policies and processes lah. To date, there are 233 certified companies who have successfully obtained the data protection trust mark. And from these organizations, the testimonials that the PDPC has received are that there are many positive impacts or benefits to obtaining a trust mark. And that will include things like being able to provide assurance to customers that you can trust me with your data because I have achieved this data protection trust mark, and the PDPC has recognized that my organization's data protection standards are up to par. We have achieved that level of accountability that's expected under the PDPA. It will also include things like raise business competitiveness and increase overseas market access. Because I think particularly where if you're going to deal with counterparties in jurisdictions where data protection is a big thing, like for example in Europe, whereby the awareness and consciousness of data protection is very high, the existence of the trust mark has been found to be beneficial, whereby there have been companies who have because of the trust mark, they've been able to win a tender over their competitors because of the fact that company A, company B, they both look pretty good, but we rather partner with company A because they have this trust mark, and and we are able to have more confidence that we can share our data with them and they will keep it safe. Also, accountability to regulators, if you look at number 4, similarly to the DPE just now, the fact that an organization has received a data protection trust mark will certainly be a positive or mitigating factor when it comes to the PDPA's assessment of the extent to which an organization has breached the PDPA in the event of a data breach. So certainly there is that value there. Right. So as I mentioned, if you look at the left side, if there is a DPTM certified company who has suffered a data breach, they can request an undertaking in lieu of an investigation. So in other words, in lieu of any kind of formal finding of liability by the PDPC will accept an undertaking or a commitment by the organization to put it to address whatever happened that caused the breach, and the PDPC will close the case based on that. Even if there's no undertaking, the DPTM also can serve, as I mentioned, as a mitigating factor that will reduce the financial penalty or reduce the severity of the breach when it comes to the PDPC's assessment of its enforcement findings. Similarly, as I mentioned, in terms of government procurement, so I guess I gave an example of an overseas tender, but also within the government, when it comes to your GBiz tenders. The fact that an organization has received the data protection trust mark has been found to be a differentiating factor when it comes to these tenders. And similarly, in the area of cyber insurance, we have found that DPTM certified organizations have better cyber insurance processing and competitive offers, like because of the fact that I guess there is less risk to insure, given that the trust mark standard has been achieved. Right, and again, going back to that better data-driven business program that I mentioned, again, it's a business intelligence tool that is offered by the PDPC, that is developed in partnership with Microsoft, to enable SMEs to sort of kickstart their data analytics, or their use of data analytics effectively. So there is that tool that exists, and there is also training that exists to assist organizations in putting that tool into effect. So for organizations who want to use that tool, it's available on the PDPC website, but I mean, these are the QR codes if you're interested. And there are two different tools. There is the BI tool for B2B SMEs, as well as the BI tool for B2C SMEs. So because of the different nature of B2B and B2C businesses, there are different analytics tools that are being offered together with that within that particular BI software. As mentioned, there's complementary training for SMEs by IMD and Microsoft in the use of data analytics and the use of that BI tool, and increasingly also in the use of AI, if that's something they are interested in. Again, for the different things that I mentioned, the Data Protection Essentials Program, you can find it on the IMDA's website. Here is the QR code. Similarly, for the certifications like the Data Protection Trust Mark or the APEC cross-border privacy certifications. So just to briefly mention, I mean, those two certifications are to facilitate and enable the transfer of personal data overseas, because the existence of this certification can be used as a grounds or legal basis for transferring data out of Singapore. So, if you recall what I mentioned about the legally enforceable obligations that must be imposed on the recipient, an alternative route would be by obtaining certifications that can be used as an alternative means of complying with the transfer limitation obligation. And again, finally, the Better Data-Driven Business Program, that's also on the IMDA's website. Right, so that brings me to the end of this first session. Happy to address or take whatever questions that you guys have. Oh, sorry, Gwenly, I think you're on mute.
No. Hello, can you hear me?
Yes, I hear you now.
Okay, can. So I think we can start the Q&A, right? Just one line. Can you waive your rights to be governed by PDPA?
As in, I assume you're talking about the individuals, right? Or you're talking about companies. So
I think maybe you address on the both side, because
yeah,
this
I guess I'll take both lah. So when it comes to whether the PDPA applies to companies or not, that is not something that you can choose lah. Right? I mean, you can't choose what laws apply to you or don't apply to you. I can't say that or Singapore income tax law doesn't apply to me, then I don't need to pay taxes. The PDPA applies to all organizations that process, collect, use, or disclose personal data in Singapore. There's some kind of debate about the extent to which it can apply to companies outside of Singapore, but for all Singapore companies, it definitely applies. On the individual side, you again can't really waive the application of the PDPA, but you can choose not to exercise the rights that you're available to you under the PDPA. So, if you can choose not to exercise your right to access or correction. You can just consent to whatever you want, and you don't care about what you consent to after that. So in that sense, there's no waiver of applicability, but the individuals can choose which rights under the PDP they want or don't want to exercise. sorry, Glenn, I don't hear you again.
Maybe I'll take over. So another question that they asked was, are the banks governed by PDPA?
Yes, yes. So as I mentioned, all organizations that collect, use, or disclose personal data in Singapore will be governed by the PDPA, and that includes the banks. Although for banks there is an additional layer, because there is the idea of banking secrecy under the Banking Act that needs to be complied with. So for banks, there is kind of a dual layer of compliance that is needed, both in terms of personal data when it comes to complying with the PDPA, as well as in terms of banking customer data when it comes to banking secrecy. So for banks, those two need to be considered in tandem. But yes, the PDPA does apply to banks.
Okay, thank you. So the third question raised was, is it necessary for us startup founders, including the fintech and Web3 space, to utilize PDPA when it comes to seeking investments and funding from angel investors and venture capitalists?
Right. So okay, I think there's kind of two aspects to that lah. So I think the first aspect is that when you're talking specifically about the data of your VCs or your angel investors, there's a concept under the PDPA called business contact information. So if there is certain personal data that quite broadly speaking, personal data they can find on the name card, right? So the guy's name, his or her position, his or her email address or phone number. Those data, if it was given to you in a business context, so you're meeting an investor, that would be a business context. The PDPA actually wouldn't apply to that kind of business contact information. So in that context, when it comes to dealing with the personal data that you receive from your VC investors or your angel investors, there is actually the PDPA actually wouldn't apply to that. But if you look at it more broadly, when it comes to investors looking at your company, so if your company is one that does process personal data of customers, for example, or your own employees, for example, investors would want to look at the extent to which your organization has in place at least a basic level of data protection, compliance policies and practices. Because from an investor's point of view, if the organization doesn't have that, it's two things. It's first is it's an additional compliance cost that needs to be borne subsequently, and second, it's a potential commercial or reputational risk in the event that there's a data breach, in the event that there's some kind of customer complaint or there's some kind of regulatory investigation. Those are all big issues that may arise and may affect the value of the investment or value of the company if they do arise. So in that context, the PDPA would be important.
Thank you. Okay, the next question is PDPA also applicable for corporate clients, legal entities whose users are private persons acting in the name of the LE?
Yeah. So I think I kind of just answered that when I talk about business contact information. So similarly, if your customer, if what you're dealing with is a company, and the information that you collect from this company or this individual who is an employee of that corporate customer, is business contact information, and it was given to you in a business context, then actually the PDPA wouldn't apply to that. But again, I think it just want to be clear that just because it's a corporate customer doesn't mean that whatever they give to you is confirmed business contact information, is confirmed not personal data. It's possible that some types of personal data that if it goes beyond business contact information could be caught by the PDPA. But generally speaking, when it comes to, if let's say it's a corporate customer and they give you their data to sign up for an account, so you just have their name, their email address, their username and password and things like that they used to generate a user account for them, then in that case, there wouldn't be any data that you collected from them that falls outside of business contact information, and thus the PDPA wouldn't apply.
Thank you. Another question asks, I see that sometimes it is okay for content creators, regardless of industry like fintech and Web3, to reveal their full names. In that case, how do we know that an unwanted data breach occurs, and how might we address this issue?
It's okay. Sorry, okay, so can you repeat the question one more time? It's okay for content creators to reveal their full name, but
Yeah. And then in that case, how do we know that an unwanted data breach occurs, and how might we address this issue?
okay, so I'm trying to sort of get where the question is coming from. And it sounds like maybe you might have engaged the content creator for 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 certain services, and because they've given their full name and it's publicly available, you're worried that maybe whatever full name of this content creator, beyond their TikTok account or their Instagram account name, you might have to protect that data. If that's the context, then I guess I would bring in another exception under the PDPA, which is publicly available information. So to the extent that certain information was publicly available and you had obtained it from a publicly available source, you there is no need to comply with the consent requirement when it comes to that lah. Although when you have the data in within your position of control, then the rest of the obligations would apply. But when it comes to the collection, then there is an exception to the consent requirement in that case. Yeah, so hopefully I caught the gist of the question and I answered it to address whatever you were thinking lah.
Another question raised, how do I know if my company has sufficiently protected data and have the right processes? Is there some sort of audit that we can do?
Okay, yeah, it's okay. This is a great question. So I think there's a couple of ways you can go about doing it. First, there is the free resources available on the PDPC website, whereby there are certain checklists that are available that you can use to do your own internal assessment as to whether you have in place all the different things that are set out in the checklist to assess your level of data protection compliance. But if you want to go a bit more in depth in terms of the assessment, it is possible to also consider engaging a external consultant to assist you with that. So if it comes to the policies, for example, you can engage a law firm. If it comes to the IT side of things, you can engage a IT security vendor, or one of the audit companies, for example. They also offer those services to provide a professional assessment and opinion as to what gaps there are within your policies and processes and how you can address those lah. So again, I guess it comes down to how confident you are in your ability to assess yourself, or if you feel that there's a need to obtain professional advice or professional support on it, then you can engage a external advisor on it.
Thanks for sharing. Another question raised was, some people claim that the fintech space is where there is a proportionally higher use of PDPA within the organization compared to other industries. Do you have any thoughts on this, and how might we manage it properly, including when it comes to telling the fintech story?
Right. So I think it's true and not true. It's true in the sense of fintech and as an industry, it is heavily data driven. I think that's undeniable, right? So much of what fintech companies do is driven by data when it comes to customer data, financial data, all those kind of things, right? That's just the nature of the industry. I mean, you compare it to, for example, like the F&B industry or things like oil and gas industry. And just necessarily speaking, there is more data involved lah. But at the same time, it's also not true because increasingly it's become ubiquitous that every industry there's some level of data that's gonna be used and is increasing in every industry lah. Everything is driven more and more by analytics. Everything is driven more and more by data science and things like that. So another aspect of this, in addition to what I just said, is I guess there's also the type of data that you guys are handling in the fintech space lah. The fact that you guys are handling financial data as opposed to other kinds of data, like if you compare to, for example, a logistics company, they mostly deal in customers' addresses, and things of those nature. But when it comes to financial data, there's that added layer of sort of sensitivity involved. So in that sense, that could be contributing to that perception as well lah. So when it comes to telling so-called the fintech story, I guess what I would say is that it's not so much trying to challenge or debunk how much data you use or don't use. I think that's probably not a productive way of going about it lah. But I think it's about demonstrating that in the fintech space there is a high awareness of what it means to process and use data in an accountable manner. There's a high level of awareness in terms of data protection compliance and what that means, and in terms of achieving accountability towards the protection of user data. I think in terms of the story, I think that's where I would push the envelope a little bit more to demonstrate the positives, right? Rather than to try and quibble over the risks in terms of the amount of data that is used or not used. I will focus a little bit more on the positive aspects of things and to demonstrate how, yes, there's going to be data involved, but you can trust us with your data, and we're going to use it to your benefit, to provide you with the goods and services that you need and that you want.
Thank you. Another question asked was, I understand that there are some content creators in this meeting. So may I know how might we utilize the power of PDPA when it comes to converting fans of content creators or social media influencers, including in the media industry, to brand advocates in the fintech space or beyond?
Okay. So I guess I kind of understand the question about content creators earlier, right? So I didn't realize that there were content creators in the audience as well. I guess in terms of leveraging the PDPA, again, as a content creator, I suppose it's a bit different because you wouldn't, your concern is not so much about compliance with the PDPA, because I don't suppose that as a content creator you would be collecting significant amounts of personal data. I mean, you would to some extent. If let's say you do certain things that involve all your followers, you run a some kind of promotion whereby you give out prizes to your followers, and then you gotta mail it to them, for example. Then you need their contact details. So there is that level of data processing that exists. But I guess compared to a fintech business, the scale and scope of your data processing wouldn't be as much lah. So I guess I would look at it from the other side of things. So not so much compliance, but rather perhaps the PDPA could be a form or a source of content creation in that sense. Given that at least this is from what the PDPC is trying to do, right? We're trying to raise awareness. We're trying to ensure that what is in the PDPA, that principle of accountability is being spread. I guess we will welcome any kind of content creators who are out there who want to help pitch out on that as well, to help build out the awareness in the industry that we're trying to create lah.
Okay, we will answer 3 more questions. Another person have raised this question. I have seen many SMEs in Singapore collecting all personal details of the candidate and all their families members, including IC, occupation, etc., before the interview itself and before the start of the discussion. Is it allowed under the employment or PDPA? This is in the context whereby no offer of employment has been made either orally or written.
Okay, so to whoever asked this question, I would agree just on what's described that this does sound a little bit excessive lah. in terms of the data being collected. For a couple of reasons. I think first and most prominently is the collection of the IC numbers of the families, of the family members, because there have been very clear guidelines that have been published by the PDPC about the use of NRIC information, and it's really quite strictly limited to very specific situations where there's the collection of the IC is either required by law, and in this particular context, the requirement is only to collect the NRIC of employees who are employed, and not candidates and not their family members. And there is also no particular security concern or risk that is being addressed here lah. So unless this is an application for, like, some high level government job that requires access to that requires some kind of security clearance, then they might need to do some security checks on those lines. But otherwise, for normal companies, I would say that it's a bit excessive, particularly on the NRIC side lah. I think this has been an issue in the past, and generally we've been advising our clients to sort of minimize the amount of data that they collect at the interview stage to what is really necessary for the purpose of what they're trying to achieve, which is to identify which candidate is most suitable for the role they're hiring for. And also beyond that, once they've completed the interview process, to not hold on to that data unless there is some specific purpose that the candidates had consented to already when they provided their data. So I think in short, the scenario described does sound a bit problematic, I would say. So yeah.
Okay. The next question, how do you give consent for PDPA? Please, can you share some examples?
Okay, so like I mentioned, there's a number of ways that consent can exist, especially with the amendments whereby there's new forms of deemed consent, right? But just taking consent in its most simplest form, it's express consent lah. So it's a common way that this is done typically is, for example, when you sign up for an account for an app, for example, you create your account, your username and password, you give your name and address or whatever, or handphone number, whatever they ask for, right, depending on the business. And at the bottom, there will be some statement that says that by clicking the I accept button or by signing up for an account, I hereby consent to my data being processed in accordance with the terms of the privacy policy that you can view here. Then there's hyperlink, for example, to the privacy policy. So this is a very common way of getting consent. So the act of clicking I accept, the act of accepting the terms of use of a platform, that is typically viewed as consent being collected. One thing I'll add to that is to say that when it comes to marketing consent, if there is going to be a use of that data for marketing purposes, there is an additional need for specific express consent for marketing purposes to be added there. So in addition to that language that I just give an example of, there would need to be like an additional line with a separate checkbox to say that the user can check to say that I consent to receiving marketing messages via my personal data from your organization, something like that, right? And that will be the express consent that is needed for the organization to send marketing messages to you via your personal data that you submitted. So that is like one common way of getting consent, but I think that's not to say that it's the only way. It really depends on what is happening, like what's the actual circumstance involved. So that it could be consent in the form of, if you fill up a form and you for example, you go to the doctor's office, for example, you register as a patient, you fill in the form, you sign, and then you submit. That could also be a form of consent, especially when there's like that consent language that's put at the bottom that I just mentioned just now, a similar consent language but in an offline form and an offline paper form. That could be consent by notification, deemed consent by notification, like I mentioned earlier, or deemed consent by contractual performance, like I mentioned earlier as well. So those are the various forms of consent, but essentially it's really just an action or a word or some kind of statement that indicates that you consent to the data being processed for the specified purposes.
Okay, thank you. The final two questions. To what degree the PDPA necessitates that the collecting company of personal information, example, an independent financial advisors, actively discloses to the customer which other company, example, B2B fintechs, the data is shared with for processing.
Okay, so this kind of goes back to what I was saying earlier about the consent and notification lah. So it is necessary to notify the customer or whoever you're collecting the data from of the purposes for which you are going to collect, use, and disclose the personal data. There is no specific need to disclose to tell the customer who the data is being disclosed to, but you must tell the customer the purposes for the disclosure. So, for example, if you say something like, I will be disclosing your data, or I will be collecting using or disclosing your data for the purpose of processing your claims, for example, you're some kind of financial advisor, then you don't need to say who exactly is going to process the claim, but you need to specify that purpose, right? So that if they consent to the purpose of claims processing, then the data can be shared with whichever company, your head office or underwriter, whoever who is going to process that claim. So that's how you need to comply with it lah. Specify the purpose, even if you don't specify the specific recipient.
Okay, the final question. How might we consider or treat the PDPA as an opportunity to drive productivity within one man or multiple people teams and organization and drive business growth?
Right. So I guess the way I would see it is that, if you think about, you recall the one of the first few slides of my presentation, it set out an overview of all the different ways and advantages of effective leveraging of data. So from that angle, the PDPA doesn't help you achieve that effective leveraging of data. But what I would say is that as a startup, right, at the early stages of your company, it is important to start early in terms of thinking about how and what policies and processes you want to put in place in terms of data protection, so that when you scale up your business, you just scale up whatever you've already put in place. Instead of you scale up your business already, then you have to undo whatever incorrect processes and policies you have in place, or need to put in place the processes later. I recognize for SMEs and startups, it's going to be a cost consideration, right? Compliance cost is definitely a real issue. But the PDPA, if you're able to address it early, you're able to build it into however you design your business model, however you design your systems, and it's already there from the start. It will really enable you to scale up your business in a much more efficient way in terms of data protection compliance. So that's how I would think about the PDPA from that perspective.
I think we will wrap up this session. So that's all for today. Thanks, Justin, for spending your time and sharing with us. While attendees, don't forget to sign up for part 2 and part 3 of this series. So yeah, actually eligible for a certificate of completion if you attend all 3 of the session. Thank you once again for joining us and have a great week ahead. Thank you.
Yeah, thanks, Sabrina. Look forward to seeing you guys at the subsequent sessions.